Eleanor Coates is another star on the green horizon, as it were, particularly in the field of wills and probate. She has an interesting background. She was... not only does she hold a law degree with honours from Monash University, but she also holds a... Monash? Yes. Also holds a degree in science specialising in pharmacology. And for that reason, as well as being head of the Wills and Probate Department at what was Kenner Croxford & Co, and is now under a different name, as I understand, Kenner Teasdale Lawyers, as well as having that role, she also has a particular specialty and interest in the field of inquests. That is, it involves her pharmacology qualification. So you've got a one-stop shop with Eleanor. If the investigation into the death doesn't prove successful, she can then do the will case after that and make up for lost ground. She has an extensive, as I've said, extensive probate experience. She's also a highly qualified mediator and a member of the single list of external mediators course. As I've said, she's done criminal law as well as probate law, and this will impress. Indeed, it impressed me in any event. She was in the winning team of the Governor-General's Moot competition at Monash in 1997. She was awarded both the Butterworth Prize and the Baldwin Prize for Wills and Probate in that year, so 97 was a stellar year, and it's been upwards ever since. I'd ask you to welcome Eleanor to the podium. Thank you.
Good morning. I'm going to talk to you briefly this morning about informal wills, which is something very dear to my heart because I was in practice quite a long time before I came to the bar, and I had the client who died before he went off and signed his will, and unfortunately he was a particularly wealthy client. So something along the lines of informal wills is very dear to me, and we were successful in obtaining probate of his unsigned and in fact unseen document. And the other area that I'll address briefly are some recent developments in Part 4 cases, some of the possibly more left-of-centre claims that have been successful and some that have been unsuccessful. So kicking off with informal wills, as most of you will know, informal wills are governed by Section 9 of the Wills Act. Under that section, the court can admit to probate a document that is not signed in accordance with the strict requirements of the Act. They can in fact admit to probate documents that are unsigned, so not signed at all, and there are various definitions of what constitutes a document. There have been cases where documents have comprised documents found on computers that aren't actually a physical document. There have been notes, there have been all sorts of things. But when you're considering informal wills, there's also some very important practical things that as practitioners you can do to basically stop yourself getting sued. Going back many years, there's the case of Hill and Van Erp, and in that case, a solicitor was sued because it was found that he owed a duty of care to the beneficiaries, so not to the will maker, but to the beneficiaries to take due care in preparing the will. And that due care can include making sure that gifts can take effect. So in Hill and Van Erp, a gift failed because the witness to the will was, at the time, the spouse of one of the beneficiaries, and so the gift in favour of that beneficiary failed, and the solicitor was sued for allowing that beneficiary's spouse to be one of the witnesses. He was found negligent, and the beneficiary won. In a New South Wales case, a recent New South Wales case, which is in the paper Fisher and Howe, an elderly lady came to her solicitor's office. She came in on a walking frame. She came in with a carer. She said to the practitioner, look, my kids are in their 70s. She never told the practitioner how old she was, but it must have been pretty obvious that she wasn't a young lady, she wasn't in the best of health, and she was living already in a nursing home. The solicitor took very firm instructions. She wanted one of her sons to benefit, and as to 50% of the estate instead of 25%, and all of her instructions were very clear and very firm. And the solicitor said, not a problem, I'll do it. Going on holidays for 2 weeks, so I'll be in touch when I get back. wouldn't be talking about the case if she didn't die in the meantime. And predictably, the beneficiary sued and said, well, hang on, you had an elderly lady not in the greatest of health, and you took 2 weeks to prepare the will. The solicitor said, well, it doesn't matter. She said that was okay. And what the court found was, well, the fact that the testator had agreed to the 2-week delay didn't make a difference. The court were very critical of the delay and for the fact that that delay was for personal reasons. He was going on holidays. And the court basically said what he should have done in this case, because the instructions were very clear and firm, there was no need for a draft to go out, there were no need for blanks to be filled in, is he should have prepared an informal will. And that can be as simple as having your client sign the draft of the instructions and having them witnessed. And that would have been enough, with proper evidence, to get probate of that document. So I guess the moral of that story really is, if you are dealing with someone who's elderly, someone who's unwell, or even someone who's travelling, these things happen, as a matter of course, if their instructions are clear and firm, have them sign those instructions, because at least then you've got something that you can put before the court and try and seek probate of to get an informal will and have their wishes take effect. It'll also potentially stop you being sued by one of the beneficiaries who didn't get what they wanted. The next case is probably one of the most, to me, the most interesting case ever, because I was in it, is Fast and Rockman. At the time I was actually the solicitor, and this is the one where Mr. Rockman was a particularly wealthy fellow. He'd given instructions to draft a will. We got the will ready. He'd sent me an email and he said, all good, I'll see you on the 24th. I'll give you a call. We'll make a time to sign it. Of course, he fell into a coma before the 24th came. He didn't get to sign it. The interesting thing about this case is it wasn't that document that we sought. Well, we sought probate of that document, but it wasn't that document admitted to probate. Whilst Mr. Rockman was in a coma, one of his executors rang up and said, look, I'm not that happy with the executor clause. Can you just change it so that instead of having a unanimous decision of the executors if there's a deadlock, it goes to a majority decision? Now, Mr. Rockman had given instructions to say you can take instructions from this fellow or another one of my executors. So there was no issue with the fact that the instructions didn't come from him directly, save that he was already in a coma. And ultimately that document was admitted to probate. It's a lengthy judgment, but if you're faced with an informal will, it's well worth a read. Justice Habsburger sets out the entire history of this area, and he gives examples of cases that have succeeded, cases that haven't, and he sets down basically what he said the test was. Mr. Rockman didn't prevaricate, he didn't delay in signing his will. It was his untimely death that prevented him from doing that when he'd already said that he was happy with the contents of the will and that he wanted to sign it. And the way that Justice Habsburg got around the fact that he hadn't actually seen this document was that he said it didn't matter. There was sufficient evidence to say it didn't matter which will was put in front of him of those 2 unsigned wills. He would have signed the one that was most recently done because, given his history, he didn't mind. He wouldn't have minded which of the executor clauses was in the will, as long as the dispositive clauses didn't change, and they hadn't. So, astonishingly for all of us involved, we actually got probate of an unseen, unsigned document because there was evidence that it was the document that he intended to be his will. Someone else more recently, before Justice Macmillan, tried to use Rockman to get probate of, again, an unsigned will, and this is the case of Rowan Storer. But in that case, a draft was sent to the client, and the letter that went out quite clearly said, this will is not valid until you come in and sign it, it's just a draft. The client was unwell, and so the solicitor did the right thing, and there was no criticism of the solicitor in this case at all. He followed up, said, look, it's been a while, you haven't gotten back in touch with us, please contact us, you need to finalise your will. Still no response. The solicitor rang and said, would you like us to come out and see you? You need to sign your will. Throughout all of these instances, there was no indication and no note of what the response had been on the part of the testator, save that she didn't sign the will. And the court were quite critical of the fact that there were no file notes. So I guess another point of practice, keep notes, because often they can be quite critical in these cases in determining whether the testator might have said, well, look, I'm really happy with it, I just don't have time. So there could have been something there, but there was no evidence before the court. There was conflicting evidence in this case about whether the testator had attended the offices and been turned away because the solicitor wasn't there, and the solicitor had said, look, it just didn't happen, and again, no real notes. One critical thing that Justice McMillan decided in this case was the testator had given instructions to leave her house to a particular beneficiary and her residuary estate to that same beneficiary. Now, as practitioners, it's pretty common to say, well, if she's getting the lot, I'm not going to mention the house specifically, I'm just going to give her what's left. And what Justice McMillan said of that was, well, her instructions were different to the draft will that went out, and so I can't be satisfied that she knew what that meant, and I can't be satisfied that she actually accepted the draft because it's not in accordance with her instructions. So again, she said, there should have been some notes about what happened in the conference, whether her instructions changed in the conference, whether that was explained to her, and so on. So again, it's another case of take notes and keep very careful notes, because in this case, Justice McMillan would not admit the document to probate because she couldn't be satisfied that in the 2 months that had elapsed between the draft going out and the death, the testator had done anything that indicated she really did want to sign the document. There was just no evidence. The next case is also a New South Wales decision, Mistrale and Aspite. It's not technically an informal will case. There was no effort to admit the document as an informal will, but again, it just, as a couple of points of practice, gives some good examples. In this case, the testator was suffering from acute myeloid leukemia, so again, he was quite unwell. His son had brought him to a cafe to meet the solicitor, and the solicitor had taken instructions, took the instructions back to the office and went about the task of drafting the will. In the meantime, the son had been ringing the solicitor, and the solicitor didn't return the phone calls. The messages went unreturned, and it took the solicitor 7 days to draft the will. There was no problem with that. The solicitor turned up at the hospital 7 days later with the document drafted. Of course, he died 10 minutes before the solicitor got there. So there was no effort to admit the document to probate because it wasn't really an informal will. The testator had never seen it, never had an opportunity to adopt it. But what the court said in granting, so the plaintiff's son sued and he was successful. Now, the solicitor wasn't criticised for the 7 days that it took to draft the will. There was no issue with that. The problem was he hadn't returned the phone calls. And if he had returned the phone calls, he would have known that the testator's condition was deteriorating and he probably would have done something more quickly. So again, keep notes, return phone calls. Even if you can't do it yourself, have somebody else return the phone call, because in that case, it cost him quite a bit. It cost him the disappointed beneficiary's share in the estate. So what these cases tell us is don't take instructions if you can't attend to a will promptly, particularly if you have someone who's elderly, someone who's unwell, or someone who's likely to travel. Refer them on. It's better to miss out on the fee of drafting a will than to face a liability claim where you're up for a good portion of the estate. If someone gives you instructions, and those instructions are clear and firm, and you don't need drafts being sent out, get them to sign them, particularly, again, if they're elderly, unwell or travelling, but really anyone who gives firm instructions, just as a matter of practice, get them to sign them and have them witnessed. You may stand a chance of getting it up as an informal will. Keep notes so that if there's going to be a criticism made later, you can stand up and say, no, hang on, I've got my notes. Because really, a lot of the criticism has not been of the actions of the solicitor, it's been of their records. And act promptly. So draft the will as soon as you can, but also return phone calls. So the promptness really covers all areas of the practice. The next area is a huge one, so I don't propose going through case by case the cases that are set out in the paper. The facts are all in there. But what these cases show is that claims against estates are many and varied. In Victoria, we have probably the broadest ability for people to bring claims against the estates. The class of claimants is absolutely open. It is anyone the testator owed a duty to provide. And as Tony said, the family dog could potentially bring a claim in Victoria. So what you have to look at, I guess, is there a family-type relationship? So what I propose doing is just skipping through the cases in very brief compass, because they give a really good example of where claims have succeeded and also where claims have gone wrong. But then at the end of that, just sum up what some of the principles that could be taken from those cases are. So if you look at Whitehead and State Trustees, which I understand Tony was involved in unhappily, we had a female companion and her son bringing a claim on an estate. They never lived together. They were never really sharing, mingling finances. But what had happened in this fairly unusual case is the female was pregnant to somebody else, started a relationship with the deceased, and he'd said, "Don't abort this pregnancy, I will help you raise the child." And he did, supposedly. And so what they said was they never lived together, but it was akin to a family relationship in a pretty unusual format. So the fact that they'd shared this child, the love of this child, that he'd taken the child to Father's Day events and so on, he'd really taken on the role of a separated parent in a sense. And the court awarded them roughly a third of the estate between the two. It went to the Court of Appeal, and the Court of Appeal upheld the decision at first instance. And you'll see in the paper a quote from Justice Neve, where she talks about relationships taking on many and varied forms, and that what she says is that if it's akin to a family relationship, even though they didn't live together, it will succeed. It also shows us, I think what the Court of Appeal judgment says is it's going to be really hard to ever successfully appeal a Part 4 case, because it is a discretion and it is a weighing up of factors. And the court really loudly and clearly said Justice Bell got it right at first instance. But then if you look at the next case, Larkin and Borg, they tried to run a similar argument in quite different circumstances, where it was someone claiming to be a long-term girlfriend. In that case, the plaintiff went down in a screaming heap. Save that she had enormous financial need, she failed on virtually every one of the factors under Part 4. What the court really said is, look, boyfriend and girlfriend never living together, no mutual anything, it's just not enough. There was in fact evidence that by the end of the deceased's life, she was sitting in a corner in the intensive care unit being completely ignored by the deceased and his new girlfriend. So it seemed to be a bit of a case where perhaps she'd tried to hang on to a relationship that just wasn't there. There was no dependence, there was no mutual commitment to a shared life. And that's really what the court is looking for in claims where someone's claiming to be a partner. And interestingly, although there's no reported decision on costs, she didn't get her costs out of the estate. She wasn't ordered to pay costs, but she did have to bear her own. So one would hope that her solicitor didn't run it on a no-win, no-fee, or if they did, as Terry said, you really want to get advice. There are claims, and I've done similarly to Terry and said, don't do it. It's just not worth running it, because there are claims that are destined to fail, and the courts are getting a bit sick of it, and they are looking at adverse cost consequences. The next category of claimants are stepchildren, and the courts have made it very clear in these two cases that there is no automatic right of a stepchild to claim against their parents' estate. But what they've also said in these two cases is that they were successful, but for very different reasons. In the Paula and State Trustees case, the obligation to provide came about because the relationship was akin to a parent and child relationship. The deceased was the only father these children had ever known. Now, interestingly, in that case, there'd been virtually no contact in the later years of the deceased's life. But what the court said is it doesn't matter. When you look back over the history of their relationship, this fellow had virtually raised them as his own children, and there was no disentitling conduct of the lack of contact at the end of the life, because it happened when their parents separated. So the mother had moved on to another relationship, one of the children had moved away geographically, one had taken ill and been admitted involuntarily into a psychiatric hospital, the other one had tried to keep contact but had been shunned by the stepfather. So again, they were awarded quite handsome amounts of the estate. In Busuttil and De Gabriel, it was quite different. In that case, there was virtually no relationship between the step-parent and the child, despite the child making every effort to keep in contact. He was a severely intellectually disabled fellow, and the stepmother just didn't want to know him. There was evidence that he'd come round and said, I'll walk your dog, I'll buy you muffins, I'll do all these things. And if she was in a good mood, he'd come in and have a cup of tea and have dinner with them. If she was in a bad mood, she'd turn him away. So there was no parent-child type relationship. But what the court focused on in this was they looked through the factors into Part 4 and brought in an additional factor under other matters. And that additional factor was the fact that the stepmother's estate comprised only assets that had previously belonged to this fellow's father. So they referred to it as a hereditary expectation. But the court were also very careful in saying, don't think this is always going to happen. Don't think that just because the estate has come from one parent into the step-parent's estate that you'll always be successful. In this case, there were no competing claims in the sense that the stepmother had no children of her own. So there were other factors at play beyond the obvious, well, everything you've got was my dad's, so I should get a piece of it. He had enormous financial need. He had $40 in the bank. He was living in government housing, and by all accounts, it was quite uninhabitable, and it was really unfortunate. He asked for a house, and what the court said is, well, if we give you a house, you're not going to be able to maintain it anyway because you don't have the means to do that, and you've got government housing. So what we're going to do is give you a lump of money to be looked after on your behalf so that you can live where you are but live more comfortably. Another case that, again, failed was Webb and Ryan. These people were business partners. Over a long period of time, the deceased and his wife had no children of their own, so the estate was going to nieces and nephews. And they thought, well, let's give it a shot. Now, interestingly, this one went through a summary judgment application and survived by the skin of its teeth. Associate Justice Zammit basically said in the summary judgment application, which is a separate judgment, look, probably not a really good claim here, so it would have probably failed on the new test. But she said, this litigation is so far advanced, you've had your affidavits by the plaintiffs, you've had your affidavits in reply, you've had your mediation, you're ready for trial, you may as well run it. She found that it was in the interests of justice, given the advanced state of the litigation, to give it a shot. Of course, it came to trial, they lost, and they got a costs order against them, partly on the basis that they really should have known by the Associate Justice Zammit's comments at summary judgment stage, it really wasn't a good claim. Now, again, there's another judgment about the costs, which is well worth a look. But I guess the moral of that story is things have changed a bit since Lysart, so you may have more hope. But if you are going to bring a summary judgment application, do it quickly. The only case in Part 4 that has succeeded in summary judgment was actually done before the defendant put in answering material. What they said was, your material, plaintiff, is in, and it doesn't amount to anything. Once you descend into argument about whether there's merit, whether there's not, the court aren't as interested. So if you're going to do it, look carefully at the plaintiff's material. If you're not satisfied that there's a claim there, that's a good time to bring a summary judgment application rather than further down the track. The next category are one that come up fairly frequently, grandchildren. The judgment of Scarlett and Scarlett is a really good one because it lays down a series of principles that the court will look at in grandchildren claims. The court made it very clear that grandchildren do not have an automatic entitlement to claim from their grandparents' estate. If there's a relationship, again, more like a parent and child, that might be a factor. If, in this case, the plaintiff's father had predeceased the grandmother, and the court said, well, look, she's missed out on that expectation that her father might have inherited, and she might have therefore inherited from him. But the court went further and looked at the relationship between the grandparent and the grandchild, and they found that in this case, given the relationship, given that the other son, the surviving son, had benefited from his father's estate, that this was worth something, but it was a small estate, and so she received quite a modest award to meet her immediate needs. She got $60,000, which for her was enough to move out of home, get a place to rent and pay for some study. So it dealt with her immediate needs. The next case I found quite interesting. It's a former daughter-in-law and her children. So she was no longer a daughter-in-law. She divorced the son, And not only had she divorced the son, but she hadn't spoken to the testator or the deceased for probably 8 or 9 years before her death. So since she walked out on the husband, since she'd separated, there was actually no contact at all. But what the court said was, if you draw the line there and look backwards, there was 39 years of great contact, and she had made enormous contributions to the estate of the deceased. It was a farming property, and she'd given up work to live and work on the farm. She'd built a business on the farm to the benefit of the deceased, and the court gave her credit for putting up with her husband, who was the son of the deceased. He was said to be an alcoholic. He was a difficult man, and the court basically said, look, this woman has raised your grandchildren, give her some credit for that. And she did quite well. She walked off with $800,000 of a $3.1 million or $3.7 million estate. But interestingly, what the court did in this is she actually went to the court asking for $500,000 and was awarded $800,000. And the reason that she got more than she asked for was the court said, look, we're not going to give it to your 3 adult children who were seeking $100,000 each. We're going to give it to you, and then you can look after your children with that money. So again, unusual kind of relationship. You think, well, they're divorced and there's been no recent contact. The court didn't care. They looked at the totality of the relationship. Another one from left of centre was a cousin who brought a claim, and I will leave it to Terry to even try and pronounce the name in that one. But thank you. What had happened there was this fellow had died without a will. Again, the testator in this case was intellectually disabled, so he wasn't capable of making a will. And his beneficiaries took on intestacy. Now, interestingly, what the court said in this case was it doesn't matter if a person benefits by default or whether they benefit under a will. It's no easier to displace that initial freedom of testation. They really counted as if he left a will. In this case, the cousin was the man on the ground. He was what the court described as the go-to man. He was the only relative in Australia, and the family relied really heavily on him in caring for the testator who had serious needs and mental health issues. And again, the court looked at competing needs, and it was a bit of a decision of, well, why wouldn't you? The other relatives who were benefiting barely knew the deceased, and they had no real competing needs. They were all elderly people in Greece. They were living on pensions, some of them owned property. And in this case, even though the plaintiff had modest means, he had his own home that was paid off, he had a nest egg of $230,000 already, the court said, well, look, given his age, given his health issues, let's give him another, I think they gave him $150,000 out of a $217,000 estate. So again, he took the majority of the estate. In Alabarcus, it's quite an interesting one when people say, well, they're estranged, they shouldn't get anything. It's a very common thing that I've heard from quite a few practitioners. Why do they get anything? They've had a terrible relationship with mum, dad, or whoever it was. In this case, what the court said is the estrangement had happened quite young. And so what the court said was, look, you can't really blame a younger person for an estrangement. As the years go on and they mature, the blame for that estrangement becomes a bit more shared. In this case, there was evidence that she had tried to make up with her father and that things were starting to heal. They looked at the factors of inter vivos gifts because she had received one, but they looked at her needs. And in this case, they didn't count the estrangement as disentitling conduct. And again, she received a fairly decent piece of the estate. The judgment's also interesting because it was a real balance between the only asset in this estate was a farming property being farmed by the defendant's sons, who were the executors, and to give her anything meant to take something away from them, and they had given up their lives to farm the property. They had no education, they were in their 40s, they really faced no prospects of doing anything other than maintaining the farm. And the court still said, look, we're going to give you something. Defendant executors, it's your problem how you fund it. We're giving her an amount of cash with the expectation that they presumably mortgage the property to pay her out. The last one I found quite fascinating is Borba and Keane, where there was no biological relationship at all. The plaintiff was a young lady who lived in the Philippines. She'd never lived in Australia. She knew her father by contact. They kept up by email. He sent her money and child support, and he blindly accepted that this child was his daughter. Apparently she wasn't. The mother had given evidence at the trial saying, I've never had a relationship with anybody else, absolutely must be his child. They went off and got DNA testing, and the mother's credibility was shot to pieces. So despite the fact that, and it was interesting, the father during the lifetime had said, look, I'm not sure you're my kid. Send me some hair with some follicles. I'm going to get it tested. And she did it twice, and he never went off and got the test done. And what the court said is ultimately it doesn't matter whether she was in fact the child or whether he just thought she was the child. The fact is he thought she was. He supported her like a child, and so he really had to pay for that. Now, this is an example at the other end of the spectrum from Scarlett and Scarlett, where you've got a sizable estate in the millions, and they catered for this young lady's needs now, and they bought her a 5-bedroom house in case she wanted to have some children in the future or have her parents move in, and they paid for education that she may or may not have in the future, and if she was going to come to Australia for that education, they gave her some money to look after herself in Australia. So again, quite a generous settlement, $675,000, and the evidence was that in the Philippines that would virtually make her a multi-millionaire, to such a degree that the court structured the settlement to keep it in the senior master's office so that she wasn't robbed blind when she got back to the Philippines with this money. So again, a really good example of if you've got enough money in an estate, you don't just look at somebody's needs now, but you can look at their needs into the future. So that's a real snapshot of some current cases, but you'll find, as I said, a lot more facts and detail in the paper. Thank you.
Well, I don't know about you, the members of the audience, but myself, I have found this a most informative and illuminating session, both on matters of fact, on the cases, and matters of law. Both Terry and Eleanor have really enlivened recent developments in the field of wills and probate, and both have presented extremely succinct and yet informative papers, and I'd ask you to jointly thank them for that performance. Without being too self-serving, I really do think that they illustrate the depth and width of ability of the juniors on our list, certainly in this field, but I can say from personal experience in other areas of the law. Now, 10 minutes of questions. I'll stay here, and the presenters will be at the table with their microphones. Questions on any of the... There must be some questions. I've got many questions, but I'll leave you to ask them. A microphone's being handed to you by our esteemed client.
Hi. I have a question in relation to the matter regarding the mother who left wishes regarding the care of her daughter, and the executor then had to cop the family law costs and wasn't able to claim those costs from the estate. Who would be an executor in this day and age in that situation? She was simply following the instructions that were left in the deed of wishes.
Yeah,
correct?
and the point in that case was that the statement of wishes were not binding on the executor.
Right, so she could have said, no, I'm not going to launch into a family law proceeding.
She could have, but she thought that the parenting orders were necessary in order to keep the contact with the child here in Australia, and there was no criticism of the executor actually taking the family court proceedings. It's just that the cost involved was not for the benefit of the child ultimately, because the father had the case there was that the father had ultimate custody, and so Justice McMillan she didn't have a crystal ball in front of her. She couldn't finally decide that the family court would in fact grant parenting orders for the executor.
Right.
So she didn't think that it was appropriate for the estate to incur costs in a related proceeding in another jurisdiction where there was no certainty of an outcome. So that was why the executor did not succeed in obtaining a cost in that case.
Radio. Okay.
Yeah.
Thank you.
Other questions? Yes.
I don't mind who answers this, but how would you suggest you protect yourself from being sued where you've got a client who's prevaricating?
Prevaricating in terms of...
In executing a will. For
Signing
instance,
a
I've
will.
drawn a will, sent it to him.
I'd put it in writing straight away, directing him to make up his mind one way or the other.
Yep.
In giving instructions and giving a short giving a short summary of what the alternatives are available to him,
Yep.
and tell him to do it and do it quick.
That's right. And what the LPLC says is also explain the consequences of not having a will. So if you don't sign this document, your estate is going in accordance with your old will, your circumstances might have changed. If you don't have an old will, your estate will pass on intestacy, and again, that may not meet your wishes.
This is a sophisticated client. You still think I should put it in writing and do that?
Absolutely. Because
Even more so.
Yeah, a lot of the criticisms come from the lack of records and the lack of written correspondence and documents.
You're not really doing it for the benefit of the client so much
Yeah.
as for your own protection as well. I mean, it works both ways. You're obviously advising your client, these are the consequences if you don't sign your will now, but you've got something to fall back on if nothing gets done ultimately because of prevarication. You've got something to fall back on. That's the
Thank you.
Bruno Aldericchio.
What tips or suggestions do you have in regards to drafting wills in relation to, one, preventing potential Part 4 claims, and two, obviously a lot of solicitors are getting sued. What tips do you have in that? How far should, for example, inquiries by a solicitor of the will maker be made? And what type of wording in wills, for example, do you ask to recite the history of what has occurred during the testator's life where there might be unequal distributions in a will?
Eleanor, and then Terry.
Okay, in terms of the Part 4 aspect and reciting things in the will, often I found in practice, don't put it in the will, put it in a letter. If the client's got something to say and an explanation to give, put it in a letter stored with the will, because obviously the will's going to be admitted to probate. They may or may not want all of that stuff made public. So a detailed letter can go quite a long way towards that. And in terms of how do you stop someone bringing a Part 4, at the moment,
Can't.
it comes down to a question of estate planning. If they've got someone, make them joint tenants on a title, make them joint owners so that they can take on survivorship. There can be a pretty big amount of trust, but there is no way to draft a will that will stop someone bringing a Part 4 claim.
I've seen some wills where they've included a clause in there that the testator has received advice about possible Part 4 claims, understands that advice, understands the distributions that he or she have made in the will. Now that just gives the court some indication that the testator has considered very carefully his or her obligations.
Can I add to those two very apt summaries with which I agree? Two things. The first is, this is very cynical, but it's happening more and more in direct response to that sort of situation, Bruno. Tell your client, presumably ageing client, to give it all away into Vivos, so that he's got nothing when he or she dies. Alternatively, have it put in trusts so that it doesn't find its way into a will, as part of the estate. They're the two other suggestions I have there. You can't make any will bulletproof. You can, however, put in statements, clauses by way of statements. If there's a particular person who he doesn't want to benefit, say a relative who's been hanging around, or an indigent son who's behaved very badly and gone through family money, etc. You can put a clause in a will in some detail explaining why that person hasn't been left that money, but even that's not bulletproof, because that could end up before a judge of the Supreme Court and be found to be not the statement of a wise and just testator. It's a question of judgment, ultimately. Questions? More questions? We've got another 5 minutes. Yes, Barry Fry.
The situation that is becoming increasingly frequent, you get instructions from a relative, dad's dying, he's in hospital, wants to change his will, you dash down there because you're told he may not have long to live. You take instructions as best you can. You then have real reservations about his capacity. Do you get him to sign up even though you've got these serious reservations about capacity? Sign the instructions at that point, or how do you handle that situation?
doctor, I think.
You often can't get a doctor out of hospital to do anything.
Yeah.
They won't talk to you, they won't.
They're afraid of being sued far more than lawyers. Far more than lawyers. I'll leave that to our presenters too.
That's a really tricky one. If there's a history of medical issues leading up to the signing of the will, you'd want to get in early and get some medical reports showing that the instructions that are being provided are, sufficient. It's very rare that people just roll over and die the day that they make their will. So if there is a history of illness, start to get that medical evidence up front and it may be just a monthly update, a monthly medical report to show that there still is capacity, there still is the ability to understand and provide instructions. If you've got 3 or 4 medical reports on file that show that, you shouldn't have any issues. But it is a tricky situation.
Eleanor?
And I'd add to that if they are looking pretty crook, I'd get them to sign their instructions. I mean, at worst, you don't go for probate if you discover that they don't have capacity.
True. That's a good tip. Questions? Further questions? Yeah. Daniel Keller.
Thanks. I just have this rather undeveloped thinking about getting instructions signed as a temporary will. That it's probably useful to get them signed formally and witnessed by 2 people, etc., to avoid having to go through the Section 9 procedures. And it seems to me there's a fair bit of potential for developing instruction forms so that they can be signed in that manner. But I'd be interested to hear the panel's views on that.
Well, personally, I agree with your observations. I can't see the harm in having some formal form that can be tendered to the deceased with witnesses and signed, because that's putting the case at its highest. It's really only in difficult circumstances that you'd rely upon as Terry has observed, and indeed Eleanor, that you rely upon the informal note, signed note. I mean, that seems to me is a fallback position, but the primary position would be what you suggest of having some sort of form developed. So long as I suppose ultimately it's not seen as supplanting a properly drawn up will. That's the qualification. What views do you have?
Yeah, that's the point I was going to make. A form can easily be construed and ultimately interpreted as the will. So I guess just be careful how you formulate that document and perhaps head it as instructions for informal will or something to delineate it from the actual finally drafted document that will eventuate.
Well, that's it. Even a note that basically says, I declare that this will be my will until my formal will is drafted, and then act promptly to prepare that will.
Yeah.
Any other questions? We've got time for a few more. Yes. Mitch McKenzie.
I was just interested in page 14, paragraph 14 in Terry's document where she's talking about costs. And there's a lovely phrase in there, the last part of that paragraph 14, which says they form authorities for the proposition that a court must carefully consider protracted and expensive cost orders which may have a detrimental effect on the party ordered to pay them. And I was rather taken by the notion that you could have a cost order that didn't have a detrimental effect, and I'm sure there's a little more to it, Terry. What's that really about?
Yeah, that case, I didn't have time to go through it, but that case involved, it was a special referee. There was a dispute over the valuation of assets of the estate. It went off to a special referee. There was a family trust involved, and the executors were forced to sell, it was a Porsche, I think, and a property in Rye, because there was a question about whether the family trust that had referred the matter off to special referee, whether it was liquid enough to pay the estate. the amount of whatever the special referee had ultimately decided was liable to be paid to the estate. And so they went off and sold the assets. It turned out that the family trust, the wife was a sole director and shareholder of. It turned out the trust was insolvent, and she should have known that it was insolvent, and therefore the application to force the sale of the car and the house would not have been necessary if she had just, you know, done her job and stopped and acceded to that sale. So there was an application for indemnity costs against her because she should have known better and she should have realised the trust was never going to be able to pay the estate. And what Macmillan said was that just because the behaviour of a person in litigation is obviously wrong, it doesn't necessarily follow that indemnity costs order will be made. And she also relied on those decisions of Associate Justice Wood and who was the other one, Justice Croft in Sunland, that there will be a consideration for indemnity costs orders. Whilst it may appear obvious that they should be awarded, what's the point if they're not going to be paid, and that the person against whom the orders are going to be made is not going to be in a position to reimburse the estate. It is a consideration that the courts will take into account. But I mean, it is tricky because you want to slam someone for costs for doing the wrong thing, and you want to get in there and go, look, you know, you did the wrong thing, pay for it. But what's the point? I mean, you're kicking a dead horse when it's down, and that's what the courts are alerted to. That's the context in which that comment was made by Her Honour.
Well, on the forced sale of the Porsche, I think that's an appropriate time to conclude these proceedings. It really brings tears to my eyes, and I'm sure it does to all of yours. I'd like, once again, to thank our two excellent presenters and their excellent presentations to this seminar.